Okay, I'm going to start with jury charge. This is a DUI precedent case. The vocabulary preview includes preponderance of the evidence, circumstantial evidence, stipulate, stipulation, essential element, disregarded, instructions, scrutinize, applicable, convincing, regardless, courteous, generally, existence, justified, and character. Ladies and gentlemen of the jury, before I charge you with the law applicable to this case, I wish to thank each of you for your courteous attention to all of the witnesses, and to thank you for the long hours you have worked, period, paragraph. Now that you have heard the evidence and arguments of counsel, it becomes my duty to give you the instructions of the court as to the law applicable in this case. It is your duty, as jurors, to follow the law as stated in the instructions of the court, and to apply the rules of law so given to the facts as you find them from the evidence in this case, period, paragraph. You are not to single out one instruction alone as stating the law, but consider the instructions as a whole, period, paragraph. Neither are you to be concerned with the wisdom of any rule of law stated by the court, period. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in the instructions of the court, period. Also, it would be a violation of your sworn duty, as judges of the facts, to base a verdict upon anything but the evidence in the case, period, paragraph. The burden is on the plaintiff in civil actions such as this, to prove every essential element of his claim by a preponderance of the evidence, period. If the proof should fail to establish any essential element of the plaintiff's claim by a preponderance of the evidence, the jury should find for the defendant, period, paragraph. To establish by a preponderance of the evidence means to prove that something is more likely so than not so, period. In other words, comma, a preponderance of the evidence in the case means such evidence as, comma, when considered and compared with that opposed to it, comma, has more convincing force, comma, and produces in your mind belief that what is sought to be proved is more likely true than not true, period, comma, paragraph. In determining whether any fact in issue has been proven by a preponderance of the evidence in the case, comma, the jury may, comma, unless otherwise instructed, comma, consider the testimony of all witnesses, comma, regardless of who may have called them, comma, and all exhibits received in evidence, comma, regardless of who may have produced them, period, paragraph. There are, comma, generally speaking, comma, two types of evidence from which a jury may properly find the truth as to the facts of a case, period. One is direct evidence, comma, such as testimony of an eyewitness, period. The other is indirect or circumstantial evidence, comma, the proof of a chain of circumstances pointing to the existence or non-existence of certain facts, period, paragraph. As a general rule, comma, the law makes no distinction between direct and circumstantial evidence, comma, but simply recognizes that the jury find the facts in accordance with the preponderance of all the evidence in the case, period, paragraph. And I believe I said recognizes instead of requires in that sentence. I'm sorry. Next paragraph. Statements and arguments of counsel are not evidence in this case, period. When the attorneys on both sides stipulate or agree as to the existence of a fact, comma, the jury must, comma, unless otherwise instructed, comma, accept the stipulation and regard that fact as proved, period, paragraph. Any evidence as to which an objection was sustained by the court, comma, and any evidence ordered stricken by the court, comma, must be entirely disregarded by you as jurors, period, paragraph. Unless you are otherwise instructed, comma, anything you may have seen or heard outside the courtroom is not evidence, comma, and must be entirely disregarded. Period, paragraph. You are to consider only the evidence presented in this case, period. But in your consideration of the evidence, comma, you are not limited solely to what you see and hear as the witnesses testify, period. You are permitted to draw from facts which you find have been proved, comma, such reasonable inferences as seem justified in the light of your experience, period, paragraph. You, as jurors, comma, are the sole judges of the credibility of the witnesses and the weight of their testimony deserves, period. You may be guided by the appearance and conduct of the witnesses, comma, by the manner in which the witnesses testified, comma, by the character of the testimony given, comma, or by evidence to the contrary of the testimony given, period, paragraph. You should carefully scrutinize all the testimony given, comma, the circumstances under which each witness has testified, comma, and every matter in evidence which tends to show whether a witness is worthy of belief, period, paragraph. After making your own judgment, comma, you will give the testimony of each witness such weight, comma, if any, comma, as you may think it deserves, period, paragraph. In this lawsuit, you will have two basic issues to decide, period. First, comma, you will want to take up the issue of whether or not the plaintiff is entitled to recover from the defendant, period. To put the same issue another way, comma, you will want to determine whether the defendant would be liable to the plaintiff.